Tonight, the purpose of the presentation is really to be educational. And my goal for you is to go over some of the basics of estate planning, what tools you can use to protect your family's assets, and to go over some of the basic terms so that if you are going in to get your estate plan done, you know the questions to ask. And also how to talk to your family members about these things. So often I have clients come in and get their estate plan in place, and then they're trying to talk to maybe mom and dad about getting their estate plan or their adult children. So we'll give you some tools tonight to have those conversations. And as Linda said, I definitely want to cover any questions that you have, so feel free to pop them in the chat. So just to start, to go over kind of what we'll cover tonight, want to go over why it's important to establish an estate plan in the first place. And if you already have an estate plan, how often should you be going back to your attorney's office to review and make changes? I think it's good to cover what happens if you pass away without a will. We all know that we should get our estate plan in place. I didn't have an estate plan for my family until I started drafting them for other people. So I understand it's not always top of our to-do list. But I think the value of an estate plan can help be explained by going over kind of what happens when you don't have one. We'll talk a little bit about probate versus non-probate assets. So when we pass away, your will governs what happens with your probate estate, but most of us have a mix of probate and probate assets. And so I think it can be good to go over the different types of assets that you have and how they'll pass after we pass away. We'll talk a little bit about the probate process in general. We won't go too deep into it, but the reason I want to cover that tonight is because I have a lot of people coming to our office who say, I definitely want to do a trust because I've heard that the probate process is a nightmare. And it certainly has been for some families, but one big myth is that it is really cumbersome. And in Maine a few years ago, they really streamlined the probate process. And so if you do end up using a will as your main estate planning tool, I think it can be good to go over what happens when you pass away and your will is being probated. I also like to cover that because often people's introduction to the estate planning process is when a loved one passes away and they end up serving as executor or personal representative for a loved one's estate. Finally, and most importantly, we'll spend the bulk of our time tonight talking about the key estate planning documents you should have. So either a will or a will and trust together, a general durable power of attorney, and an advanced healthcare directive. So it's not unusual for people to reach out to me and say, I need to get my will done. And then they leave with a collection of documents. So that power of attorney and advanced healthcare directive are documents that serve you during your lifetime, and that can be really powerful to have in place now and kind of help you avoid headaches down the road. So that's big picture, what we're going to go over. So first, again, why establish an estate plan? When do I need to see an attorney? So obviously, if you're doing an estate plan, if you don't have one yet, obviously time to reach out and get one in place. Recently I've been seeing couples who maybe have had their first child and they need to nominate the guardians in their wills. And another time to come in is when you might need an updated estate plan. So again, not uncommon for people to get their wills in place after they've had young children, and maybe now those children are off to college. You haven't looked at those documents in a long time. And even though you haven't looked at them in a long time, if something were to happen to you, those are still your valid documents that are in place. So it's good to have them reviewed every few years. And then finally, another common one we're seeing is if you move from another state. So often when you move from another state, you might not need a new estate plan, but we just want to make sure everything is in order. States have different rules on how to execute your wills and other documents, and we just want to make sure that everything is still valid and doing what it needs to be doing for you. Again, other reason to establish, probably the most obvious reason to establish an estate plan is to control what happens to your property after you pass away. You certainly have the right to do that, and you can take advantage of that right by executing your will. Another obvious one, peace of mind for relatives. So I have clients come to me who served as executors of estates for family members. Maybe they didn't have a will in place, and they realize that's a headache. They want to get things taken care of for their families. Another important reason is to select your personal representative. So in Maine, your personal representative or your executor is known as your personal representative. There are default rules in Maine about who your personal representative is if you don't nominate someone under a will. And that default person might not be the family member who should be serving as your executor. And finally, another common one we're seeing for update is estate tax planning. So another big topic we're having with clients, when someone passes away, no estate tax is owed right now in Maine if the estate is worth less than $6 million. Federally, that number is up over 12 million. But that number, it wasn't that long ago that number was $1 million. And it's really easy to get there with life insurance policies and the value of, I have lots of clients who, own their own home and got a camp a long time ago on a lake in Maine for not much. And now everyone wants to live here in Maine. And so those assets can appreciate value quickly over your lifetime. So again, just really thinking big picture reasons why you would want to come in and get your plan updated or done for the first time. So what happens if you or a loved one passes away without a will? In that case, your probate estate will pass via intestate succession. So all that means is Maine has a set of default rules about what happens to your property when you pass away without a will. And probably the biggest misconception is that if you're married, everything will go to your spouse. That is the case if you're married and you have no children or no living parents. But otherwise, there's a formula that's applied if you're married and you have children or parents as to what percentage of the estate your spouse would get. It's a flat dollar amount plus a fraction, and it depends on your specific situation. But I think a lot of people don't know that, and sometimes families are caught off guard by that when they have a spouse pass away and they haven't had a will put in place. And so that is something I like to go over with people. The other big key thing is the default rules for who will serve as your personal representative. Under our probate code, so our estate laws here in Maine, the person with priority is going to be your surviving spouse, your surviving domestic partner, or other heirs at law. And again, I've had Miles and I have had a few estates recently where someone has passed away without a spouse and a number of adult children who kind of butt heads about who should serve as the executor and or the personal representative, and it makes things more complicated. So those are just some of the considerations of kind of how things play out when people don't have a will. And so I think I like to highlight that because it helps show kind of the value of getting that will in place. Again, so I talked earlier about a probate versus non-probate assets. So non-probate, it's kind of easier to explain probate assets based off of non-probate assets. So non-probate assets are any assets that pass by operation of law because there's a joint owner. So for most married couples, they own their home in what's called a joint tenancy, meaning that if one of them passes away, the house automatically is 100% owned by the surviving spouse. But it's also common to see things like joint bank accounts, vehicles that are titled in the name of more than one person, retirement accounts with beneficiary designations. And the reason why it's good to review those is often we fill those things out, like we'll set up a bank account and maybe put a transfer on death designation. Our retirement accounts, we often fill out those beneficiary designation forms when we first set them up. Set the accounts up, and then we don't look at them again. And I'm guilty of this too. And so whenever you're talking about getting your estate plan in place, you need to look at what your non-probate assets are to figure out if how they're passing is still, pursuant to your wishes. And then probate assets are everything else. So your property that you own just in your name that doesn't have a joint owner is going to be governed by your will. And again, I'm now talking about if you have a will, but in a little bit, we'll talk about having a will and trust-based plan working together. So let's talk briefly about the probate process in general. And I do think this is important. So Maine has 16 probate courts, one for each county, and probate is opened in a county where the person who passed away was domiciled before they died. And the way the process works is your personal representative will complete the forms necessary to open probate. The forms are available online, and helpfully the Maine probate courts all have electronic filing. So a lot of this is done easily online. And crucially, as long as everyone gets along, if you're filing for probate, you typically never have to go to court, never have to go to a hearing. It's really the register of the court who will review the forms and issue letters of authority. Typically, the process takes place over about 9 months, and that's not because things are being dragged out, but there's a little bit of work in the beginning to open probate. There's what's called a creditor's claim period. So when you open probate, there's a little announcement that goes out in the local paper, and then creditors have only 4 months in which to file claims against the estate if they need to argue that any amount is owed to them. It's one of the shortest claim periods in the country, which means that once that period runs, in our office, we really talk about getting the final accounting done and getting those distributions out and getting the estate wrapped up. But I went to law school in New Hampshire. I'm from New Hampshire. The probate process there is a lot more cumbersome. You have to typically appear before the judge several times, so it's time consuming and expensive. And here, fortunately, we've really streamlined things so that it's, as painless as possible, but making sure that things get administered appropriately, which is why there's still a lot of will-based planning that happens here in Maine. So good. I want to spend the bulk of our conversation talking about the 4 kind of recommended documents, 3 or 4 that you need when you're getting your estate plan done. So the first one, again, is that last will and testament. And that is where you're going to nominate your personal representative. If you have minor children, this is where you're going to nominate the individuals or couples who will serve as guardians for those children. And crucially, this is where you're outlining the plan to distribute property, again, your probate estate after you pass away. Now, someone had asked earlier, and we get a lot of questions about whether a trust is a good planning tool. And even folks who come to us to get a living trust or what's called a revocable trust in place, even if you have a trust, we always do a will and a trust. So I guess we should first start by defining what a trust is. So a trust is a legal arrangement where you have a grantor, someone who's funding property into the trust. You have a trustee, someone who's going to manage that property for the benefit of either yourself or someone else. The reason why trusts can be such great planning tools is because, one, they're private documents. So to administer a trust, you don't need to file it with a probate court. And you can still, and also even though our probate process is very streamlined, the trust administration process after someone passes away is typically a little bit faster, because earlier we talked about that creditor claims period. There's no creditor claims period with a trust, so you can administer assets quicker. There are many different types of trusts. A revocable, so you'll hear revocable and irrevocable trust. A revocable trust is just what it sounds like, meaning you can set it up, and then if it's no longer serving you down the road for one reason or another, you can revoke it. The reason that people use irrevocable trusts are usually to take advantage of certain estate tax or gift taxing rules that require the trust to be irrevocable. Another common planning tool that we're using a lot these days is the Medicaid Asset Protection Trust. And I'm happy to talk a little bit about kind of the basics of the Medicaid rules here in Maine and why a Medicaid Asset Protection Trust can be useful. But essentially the idea behind that irrevocable trust is to fund property into it at least 5 years ahead of when someone might need Medicaid to protect the assets of that trust from the cost of long-term care. Another common type of trust is a special needs trust. So that's something you can set up on your own, or that can be a portion of your estate plan. And a special needs trust is used for individuals with disabilities who may be on public benefits or maybe on public benefits down the road. And the idea behind using a special needs trust is if you want to leave an inheritance to someone who's on public benefits, but you don't want them to be kicked off of those public benefits because of that inheritance, we can establish a special needs trust to manage assets for that individual. And finally, you might hear the term a testamentary trust. So a testamentary trust is a trust that's part of your will. So it sounds a little confusing, but the most common example, and we're doing a lot of these plans nowadays, is for a married couple with young children. And if anything were to happen to them, obviously we don't want the funds going outright to a minor child or even a young adult. And their wills will provide that the inheritance for their children go into a trust for their benefit. So even if you're having a will-based plan, you can still have a testamentary trust so that your beneficiaries are receiving inheritance in trust. And in your will, you can nominate who will serve as trustee, how long that trust will be in place for. So again, for example, I do a lot of planning for folks who leave an inheritance to their children in trust to a certain age. So often when I'm doing that plan for the first time, that age is 25. And then as people come back to me over the years, that age creeps up. I'm like, actually, I think that should be in trust till 40. And so that can be a very valuable planning tool. So we talked about the privacy considerations for having a trust and it being useful. The other common reason that we're using a trust is for anyone who owns real estate or other significant assets outside of the state of Maine. So Miles and I have a few clients right now where someone has passed away and they had property in multiple states. And if you don't transfer all of those assets into one trust, what happens is you have to open probate in multiple states. And it's not everywhere is as streamlined as it is here in Maine. And so it just multiplies the cost of that estate administration process. The important conversation we have with clients, and you've just hit on one thing, which is life insurance policies. They can be, I think people actually, when they get them for the first time, realize there are some really affordable ones out there, and that can be a great planning tool in the event that something were to happen to you or you and a spouse and you have young children. We also specifically in our documents will put language, and again, it depends on the client. We'll put language in there to address specific issues. So if you want to make sure we're leaving money in trust and we want those funds to be used for example, for college tuition, things along those lines. The idea typically with a trust is that once they're, through college or, into young adulthood, they're not relying on the trust for their whole source of income, but it's there as a resource. We also put in language, I have a common provision that says that the guardians can use funds from the trust to buy a bigger house if that's needed. Because I think that's the biggest concern that comes up is like, I have a sibling who would be great if any, a sibling and spouse would be great to care for my kids if something happened to me and my husband, but they already have 2 kids of their own. And so, we'll specifically put something in there that they can use trust funds to buy a bigger home or help to pay for some of those living expenses. And we really can tailor things specifically to the needs for that family member. Another common scenario I'm seeing is people identifying one adult sibling and spouse to serve as guardians for minor children and a different sibling to serve as trustee, because they have one sibling who's like great to help raise their children, but maybe a different sibling who's great with finances and to help out. So you can kind of spread the responsibility around among the family members. There's a federal statute that prohibits financial institutions from pulling the due on, or enforcing a due on sale clause in the event that you're transferring real estate into a trust. I don't think it applies to every type of trust, but certainly a living trust, and for the Medicaid Asset Protection Trust, those are permissible. As a practical matter, the way we usually handle that is to let the financial institution know that this is part of our estate plan. There's a federal law called Garn-St-Germain that allows this transfer. The family is still planning on making their mortgage payments, and that just helps minimize any kind of confusion either from the financial institution or the family member who is helping to manage the trust. But I just briefly want to go over kind of the basic that Medicaid rules, and again, not to go into the weeds, but I think the topic here is safeguarding your family's future and thinking about potentially having a loved one who needs Medicaid down the road, and the way that you can use trust for that type of planning. So in Maine and in every state, Medicaid is an umbrella program, term that has dozens and dozens of programs underneath it. But the most common one we're hearing about, or that we're talking about, is benefits that pay for your care or loved one's care in a nursing home or an assisted living. And here in Maine, the average cost of assisted living or a nursing home is over $10,000 a month. So that can very quickly, drain someone's, their nest egg. They worked all their lives, and now they're spending $10,000 a month on long-term care. There's different planning you can do to protect your assets from the cost of long-term care, and what type of planning you're doing depends on how far in advance you're doing the planning. So there's a 5-year look back period, which means that when someone submits, and in Maine, that program is referred to as MaineCare. So people use Medicaid and MaineCare interchangeably. So in Maine, if someone submits a MaineCare application, DHHS, the body that is going to review the application, will ask for 5 years worth of financial statements. And they want to make sure that people aren't making significant gifts within those past 5 years, because the idea is that you don't want people intentionally impoverishing themselves in order to become eligible for MaineCare benefits. And so if it's more than 5 years before someone might need MaineCare, you can transfer, typically it's real estate and other assets, into a Medicaid Asset Protection Trust. It's an irrevocable trust. And I don't want to get too far into the weeds, but the idea being that down the road when you apply, the trust assets are not countable. They're not going to be counted against you when you're applying for MaineCare. If you have a loved one who needs long-term care sooner than 5 years from now, there are still other things you can do to help protect your assets. But that trust is a great planning tool, and again, useful really when that long-term care is not imminent. So I have people coming, and I've had people come in their early 60s, and I tell them, like, come back, because you do have to give up some control. You have to name someone else as the trustee and beneficiary of the principal, but it is a useful planning tool. So a power of attorney is a pretty straightforward document. In the power of attorney, and again, you'll hear them referred to as general durable power of attorney. And durable just means that even in the event of your incapacity, your agent under your POA, as it's known, will still have the authority to act for you. And this is the document where you name the person who can help you with your finances in the event that you cannot act on your own, in the event of your incapacity. There's two types, springing versus those that are effective immediately. Springing means that your agent's authority only comes into play if a doctor, they have a letter from your doctor saying that you don't have the ability to act for yourself. We're recommending typically that people do effective immediately. That way I don't know if you've ever just tried to call your doctor's office to get a letter, but it can be a bit of a hurdle. You also can have full versus limited powers. So typically someone's coming to our office, they're preparing a power of attorney for their spouse or a close loved one with full powers, meaning that person can step into their shoes and do anything that they would be able to do to organize their finances. And then we're typically doing a second one with limited powers, meaning a backup family member who, in the event of a crisis, could essentially help you pay your bills, but you don't need to necessarily do anything that you would want, your spouse or a close loved one to do on your behalf. And the reason why these documents are so valuable is we have a relatively new guardianship and conservatorship code here in Maine. It's based off of a national model code, and it's very protective of folks who might be under a guardianship or conservatorship. And I use both of those terms. Guardianship just means someone who has the legal authority to make decisions about the person's body, like where they live, what medicine they take. Conservatorship is in regards to the finances. So our new laws are very protective of anyone who might be under a guardianship or conservatorship, which is for good reason. There certainly have been lots of cases where a guardian or conservator has been appointed and it's not appropriate. But for the families that we're working with, it means that if a guardianship or conservatorship proceeding is necessary and it's an appropriate case where it's not even a close call, it's still really time consuming and expensive. So just having this simple power of attorney document in place can prevent you from having to go to the probate court. And the way that's coming up is we've worked with a lot of family members who have loved ones who maybe have a dementia diagnosis or Alzheimer's and need some help with their finances. And just by having a power of attorney, you can avoid having to go seek a conservatorship proceeding. And again, at the beginning of the presentation, we talked about estate planning, not just for you, but having a conversation with your loved ones. And even more than in a will or anything else, this is the document you should be talking to your loved ones about, to making sure they have in place. I wanted to end for the durable power of attorney portion of the presentation, just a note on templates, which is people are finding templates or forms online and getting them filled out. And I'm seeing that lead them to trouble, unfortunately, just because templates are different from state to state. And there are specific requirements on notices that have to be included in the POA. They have to be executed a certain way. Maine, fortunately, has a law that says as long as your POA substantially complies with the law, that you are okay to use it. But what happens is I've had a few clients where the POA has an issue with it, and I can work with the financial department's legal department to basically show them that in Maine, even though this isn't perfect, it satisfies that substantial compliance piece. But that means you have to spend money on me talking to your financial institution's legal department. It's a much more expensive route to go. So just be careful with templates, or if you have family members who are like, I found a form online, I'm all set. Because those are such valuable documents. So the last one is that Advanced Healthcare Directive, also known as an Advanced Directive. Again, very valuable document that typically they include, several different parts, and you aren't required to complete all of them, but they're very valuable. The biggest one that people typically know about is this is a document where you nominate your healthcare proxy. So the person who's going to help make medical decisions for you only in the event that you can't make medical decisions for yourself. And you want that document to have the correct contact information for them so that in an emergency, they can act for you. You also can include your wishes for any end of life care. So including wishes about if you are terminally ill and, do you want extreme measures to be taken? Things along those lines. Funeral and burial wishes. This is one that people never want to fill out, but it's so important. Maybe some of you have gone through this process with loved ones where someone passes away and family members don't necessarily agree on what a family member would have wanted for their funeral or burial. It can be a really good place to take away any doubts for family members to just even put some wishes down, whether you want to be your remains to be cremated, where you would want to be buried, things along those lines. You can identify a custodian of remains. And really, I just did an estate plan for a couple who are both in the healthcare industry, and they had they interact with these in their day-to-day lives. And so they were really intentional about what they put in there as far as their end of life care, and also just like what they would want for their funeral, music, like specific things along those lines, which I thought was really beautiful. The final reason I just want to touch on is you can identify your primary care physician or specialist, like another doctor that cares for you in this document. So this is really valuable when you or a loved one have ongoing health issues. So maybe you're seeing a specialist receiving treatment for a specific issue. The idea is just that in a crisis, if you're, ending up in the emergency department for whatever reason, your treating physician can have the information where you're for your PCP. That way they can reach out, get your medical records, get your history, and make sure your treating physician is making kind of good medical decisions for you. Same thing with advanced healthcare directives. I've seen people get in trouble with templates. There is a state of Maine, I think, template, and I don't want to get that wrong, that I think is pretty good, but you just have to be careful with how the documents are executed. POAs should be notarized, and I just don't remember if there's also a witness requirement. And advanced healthcare directives have to be witnessed by 2 people, but they don't need to be notarized. So I sometimes get advanced directives that are notarized but aren't witnessed, so then they're not valid. And so I kind of wish those requirements matched for POAs and advanced directives, but they don't. And that is something that gets people into trouble. So, but again, valuable. The power of attorney and advanced healthcare directives are documents that serve you during your lifetime. They're your agents under those documents. Your agent's authority goes away after you pass away, but it's to help you weather those crises without having, again, to have to go to any sort of conservatorship or guardianship proceeding. And so those were the big points that I wanted to cover. My last practical tip about your estate, or the estate plan, is a practical one, which is just making sure if you do get these documents completed, that one, you're keeping them in a safe place in your home. Original wills really are best stored at your law firm, just because there are really strict rules around how we keep, we have to keep them in fire and flood-proof safes. When we retire, we have to report to the bar what wills we have and where, which attorney is going to take over custody of them. But even for the copies you have for yourself, you want to keep them in a place in your home where if a loved one needs to find them, they could find them easily. And then if you are, especially for the POA and advanced directive, you want to give copies to the people that you have nominated as your agents, because if they don't know that they're your agents, then they're going to have trouble acting for you. And you want to make sure they have them somewhere. That way, if, hopefully you don't need them, right? These are all to help prevent headaches down the road. But in the event that you do need them, that person can find them easily and act for you. So let's see, the question is, just in case everyone doesn't have it open, any thought on a revocable trust needed if I'm single, no children, etc.? My question is in the Q&A. Let's see. Will it make things faster? Not sure how to fund it. So again, this is always up to the individual. I think, if you're here in Maine, I think a will is fine, but it doesn't hurt to have a revocable trust. And you can have a trust that is not funded during your lifetime. So the way this would work would be that whenever everyone has a revocable trust, we also have have it paired with what's called a pour over will. So their will says that all of their probate assets pour over are distributed into the trust and then distributed pursuant to the trust's terms. So it can't hurt if you like the reasons that I mentioned for the trust process, like having the privacy and a little bit of a faster of an administration process, then that's great. But again, having a will is really a good way to go for a lot of people here in Maine. Mm-hmm. That's what I have for my family, and we're doing a lot of them. So I see another question, which is, I'm a recent snowbird and have changed my residence to Florida. I do have property in both states. Do I need my trust will to be in Florida? That's a great question. And of course, the lawyer answer is it depends. But it depends exactly how much time you're spending in each state. So I would have an attorney who's licensed in Florida review the documents to make sure, especially Florida in particular has really strict execution requirements around advanced healthcare directives and powers of attorney. So you want to make sure those are valid there, and then get advice on, again, having property in both states. For most people, a trust-based plan is going to be the way to go. And so if you don't have one yet, that now is definitely the time to look into it. But you don't have to have an estate plan, or you can't have an estate plan done in both states. One state, like it says from your question, Florida, it sounds like is your new state of residence. You'd probably have a Florida-based estate plan. Any big life change, and then honestly, I say like every 2 to 3 years, especially with the estate tax planning laws changing. There was a major overhaul in 2017. That exemption is scheduled to sunset again in 2025, which we're getting to, it's 2 years away. I'm a little skeptical if that it will actually sunset, because I think there are a lot of forces that don't want to see that exemption come down. But really every couple of years, and especially for our existing clients, part of our job is to help get your documents updated, but also as part of our job is to tell you when you don't need an attorney. So to review your documents and let you know that everything is in shape, everything is in order. I think a lot of reasons I see people coming into our office is changes in the situation for their children. So we talked about those as their kids get more established, their wishes for their, how they would want their children to receive an inheritance have changed. When people buy, maybe people buy that vacation home that they've been saving for, it's important to do planning on, often people want to leave that in trust for family members. It's important to do planning around what that looks like and how to, whether you set up a trust or an LLC, things along those lines. So major life events. And again, part of our job is to tell you, nope, everything looks good. Come back to us in a few years. And Miles would tell you this too, but often we'll get people calling me and saying, I'm going on vacation in 3 weeks. Can I come in and something changed. Whatever gets you in the door works for me. But I'd say every couple of years to just have it reviewed, make sure things still make sense for you. Our firm, and every firm is different, but the way we do it is we have an intake coordinator. Her name is Shannon. So if you call and actually I have my contact information up on the screen here. But if you call our office, Shannon, our intake coordinator, gets you scheduled for a consult. We're getting those on the books pretty quickly. So I think I'm booking out like 2 weeks, and everyone else is, I work with 3 other attorneys. So we were talking tonight about Miles, Hunt, and we also work with Dennis O'Donovan and Jennifer Kruszewski. Those are the 3 partners, and I'm their associate. We're getting them scheduled pretty quickly. And then typically to draft is about 4 to 6 weeks. So say 4 to 6 weeks, but we typically get the drafts out in 4 weeks. And the reason it takes that time is we have a second read policy in our office. So no estate plan goes out without a second attorney having read it. And that's just part of our quality to control to make sure that our documents are kind of tip top. And then what happens is, or I skipped over the consult, but Shannon gets you scheduled for the consult. We design your plan. Usually it's a 1-hour phone call. It takes about 4 to 6 weeks for us to draft and get that second read done. Drafts go out. And then if you have questions, we get you scheduled for a follow-up. And that's, I usually get people scheduled to follow up that week. And then you have you come in for a signing. So door to door, start to finish, it's probably like a 6-week process, depending on what it really depends on what your schedule is and when you want to come in. And a typical estate plan is often about 10 hours of attorney time. So it's not unusual to see a plan be about 2,500 right now. But again, the idea is that saving you a lot of headache and time down the road. And then I always tell people, if you have found out about me or our firm from a presentation that I've done, I always give like a 10% courtesy discount. Because I think it's great that people attend things like this and get that information. And if you want to learn a little bit more about our firm too, our website is willsandtrusts.com. So Wills with an S and Trust with an S. And my email address is liz@willsandtrust.com. And there's an organization in Maine called the Legal Services for the Elderly that does a lot of advising on Medicaid. I think their services are free, or maybe it's at a reduced cost, but they're a fantastic organization. Obviously, they get the number of calls they get is more than they can respond to, or they might take a while to schedule out a consult, but that's a great civil legal aid organization here in Maine. We have a lot of clients that are helping aging parents with some planning, and often, yes, you have a legal issue, like you need to get their documents done, but you have a ton of other issues with other experts that are needed. The area agencies on aging are fantastic resources for getting you connected with different organizations. There are so many organizations in the state of Maine that work with older adults. Because Medicaid and because estate planning can be really different state to state, there's lots of misinformation out there. And so I hope I've left you, dispelled some rumors and at least left you with some of those key terms. So that way, when you do go get your estate planning done, you can impress your estate planning attorney with all of everything that you've learned tonight at the presentation. So I appreciate you all taking some time out